And we're back with viewer mail, and Christie's decided to stay with us and answer some questions.
Yes.
Thank you for doing that. This is from Kelly in Statesboro. Are there limits on how often you can file for bankruptcy?
There are. There was a radical change to the bankruptcy code back in 2005. In fact, it was so radical that in 2010 we're still calling it the new law. But it did the requirements on filing are more strict, and the limits, the time frame it changed. So depends on the discharge, your prior discharge under what chapter it was, whether it was Chapter 13 or Chapter 7, and how long it had been. So, for example, if you got a Chapter 7 discharge in the past, you have to wait 8 years before you can get another Chapter 7 discharge.
Was it actually lowered? Because it didn't used to be 10 years?
No, it was 6, and it got raised to 8. But like from a Chapter 13 discharge to another Chapter 13 case is just 2 years. So it depends on what chapter you're filing under now and what chapter you got your discharge under before.
So the people who file Chapter 13, they can't file another one for 2 years. Is that if they make a plan they just can't actually live up to and they need to file again?
No, that's if they actually got a discharge, if they completed their plan, which most plans take more than 2 years, so that one they didn't really think out too well, but that's if you get your discharge. Now there are also limits, and we see a lot of people who were in a Chapter 13 plan that got dismissed. For one reason or another, they weren't able to complete it, so the case got dismissed, which means they did not get a discharge, which means their bills are still alive and well. There's also this new law in 2005 also addressed that. And if you've had, for example, one case pending within the last 12 months, then we have to submit a special motion to the court, basically saying this prior case failed because of this reason, but things are better now, and there's a reasonable expectation that this case will work. So I'm always amazed when I go to court and I'll see pro se debtors that have filed their case themselves, because this is really complicated. There are a lot of things that is not common sense and you don't think about.
Okay.
Of course, a bankruptcy lawyer will think about it.
And our next one's from Mark in Savannah, who bought a F-350 dually truck he can no longer afford. What are his options?
Option number one, and this is usually not a very realistic one, is you could try to sell it. Often, though, if you buy vehicles on credit, you're upside down. You've got that negative equity, and you can't sell it because nobody wants to pay that for it to satisfy that loan.
If that's the truck that I think it is, he's looking at like a $60,000 truck.
Yeah, those are super expensive. So that'd be your first choice. Try to sell it. Maybe that you could try to get it refinanced and get a lower payment, but then again, that is pretty unrealistic because you're not going to be able to find a creditor who's going to finance that negative equity. If you can't find somebody to take over the payments, then it sounds like bottom line, the only choice is going to be let the creditor take the vehicle back. That would be, even a lot of people think, well, I gave it back voluntarily. Well, that's still considered a repossession. And then there are steps that creditor has to take, send you letters, give you the opportunity to redeem it, and then they sell it, and then they'll allege that you owe a deficiency balance. So even if you give it back, you're still not off the hook.
Okay, if you give it back, they're just going to take it to the auction and get the first offer they can.
Right.
So they're not looking for the most money.
No, right. That's the way they dispose of it, is typically to send it to the auction.
And then you can't sell it because you don't have a title to go with it.
Right. Well, and yeah, you wouldn't be able to, in this situation, you can't sell it for what is owed on it, and the creditor's not going to just take a loss like that. So they would, whether you voluntarily took the vehicle back to the dealership or they sent the repo man out to get it, they sell it, say, well, you owed $45,000, we can only sell it for $20,000, you still owe us $25,000. Which stinks because you don't even have the vehicle. From there, they would get a judgment against you and could start garnishing your wages. Now, bankruptcy would give you more options. Often I see people who have gotten behind in their payments because they take the Gulfstream people who were furloughed. They had that furlough, so they couldn't make their payments, but they're back at work now making good wages, and they can pay it going forward. Well, that's a perfect scenario for Chapter 13. you could put that vehicle in your plan in Chapter 13, and over that 5-year period, it would get paid for. That's if you had the income to fund that Chapter 13 plan. Sometimes, depending on how long ago the vehicle was purchased, you may not have to pay the entire balance. It may be able to be reduced through your Chapter 13 plan. If you decided just to let the vehicle go, then that deficiency balance that this creditor alleged against you would be unsecured, which would be taken care of in a bankruptcy plan, whether it's 13 or Chapter 7. So there are lots of options, but once that creditor sues you, gets a judgment, the clock is ticking because they can start garnishing wages. Okay. And it's so much easier when people come to us before the creditor gets that judgment. You know, I tell people, if you get anything, get served any papers, let us know immediately, because as long as we can get the bankruptcy case filed before that judgment is entered, it really is a lot better.
Okay. Our next one's from Dan in Savannah, who wants to marry his ex-wife again. And he's paying child support through the courts. How does he get all that process to stop?
Boy, that's kind of complicated. Well, obviously, even though that order would be in place, if the child was residing with him in the future, if there was ever a problem about child support, they would consider that. Gosh, probably the safest thing, though, would be to go get a modification of that order stating that the parents are residing together and it's no longer owed. It can get complicated, and a lot of people underestimate the effect of that order. You know, I'll have people who say, well, when we got divorced, my daughter was living with my wife, and I was supposed to pay her child support, but she's been living with me for 2 years, and we didn't go back to court, so I'm not paying her child support, she's not paying me. And my thought is always, you know, if the wife is reasonable and she's never going to allege you owe anything, then that'll be great. But if not, the safest thing is to get that order amended. And you can do it voluntarily, where you both sign, submit it, it's done. But it's official.
Okay, well, thank you so much, Christie. Hope you enjoyed this episode of Talking Law TV. If you have a question for Christie or any other attorneys on the show, you can reach us through our website at talkinglawtv.com, and also watch all of our episodes online at 24/7. And you can call our toll-free number at 888-203-7LAW. That's 7529. Hope you enjoyed this episode. We'll see you again next week right here on Talking Law TV. Bye-bye.